The November 12th, 2014 meeting of the Planning Commission of the Parish of Ascension will come to order. Let the record show that all members of the commission are present except Mr. Gasper Chafisi. Will you all rise and join me in pledging allegiance to the flag? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Will the staff please introduce themselves?
Stacy Webb, Secretary for Planning and Development.
Lindsay Manda, Legal Counsel.
Ricky Compton, Planning and Development Director.
Ben Moran, Planner.
Lance Brock, Zoning Official. Mike Petty, Senior Project Manager.
Jason Taylor, Engineering.
Thank you. My only comment is to acknowledge that the Parish Council Chairman, Mr. Randy Cluot, is present, and we welcome you here. And also, another comment that I'd like to make is that when the public is speaking tonight, please confine your comments to 3 minutes. The buzzer will go off, and please stop at that time. And each person will be allowed to speak for that allotted time, and then that's it. All right, thank you very much. And do I have a motion to approve the minutes of the previous meeting?
I so move.
Second.
I have a motion and a second to approve the previous meeting's minutes. All in favor?
Aye.
Aye.
Those opposed? Minutes are approved. All right. The first item is 9A, public hearing to approve or deny the following family partition. Lori Alicia Fridge, Brumfield property.
James Falgo representing Miss Lori Fridge, Miss Lori Broomfield, on the following family partition. Asking the commission for approval.
Staff, have any comment on this?
No, sir.
I'd like to open a public hearing for anyone who'd like to make a comment about this. Has anyone indicated? So in that case, I'm closing the public hearing. Do we have any discussion here on the commission? In that case, do I have a motion?
Move to approve.
Do I have a second?
Second.
All those in favor?
Aye.
Those opposed? Thank you. The next family partition item is Larry Richardson and Shane Richardson properties.
Representing Mr. Larry Richardson on the following family partition. Asking the commission for approval.
Does staff have any comment on this one?
I just want to point out there's an existing 40-foot private access servitude on the property. If they get approval, they're going to be relocating that to a more convenient place. The relocation of that doesn't have anything to do with y'all's approval necessarily, but that's something that they intend to do afterwards.
Thank you. I'd like to open a public comment period. Has anyone, in that case, I'll close the public comment hearing. Any discussion here among the council?
Move for approval.
I have a motion. Do I have a second?
Second.
I have a motion and a second. All those in favor?
Aye.
Those opposed? Thank you. Next item for approval or denial of family petition is Alan D. Gates property. 9C.
Good evening. Clint Quintmall representing Alan Gates and W.J. Quintmall Surveyors, asking for Planning Commission approval on the following family partition.
Any staff comment?
Well, I made an adjustment, so.
Okay.
On lot 5A1, the shed has been torn down. So it has been removed from that front lot. The note for 5A3 still exists on that condition of that mobile home and that shed with a water well in it on 5A3. In addition to, I have extended the L-turn another 15 feet for the comments for the L-turn being extended another 15 feet.
Now, the problem with the structures is that they were inside of the servitude?
Yeah, there was no possible way that we could, they're in the building line, not in the servitude. Went ahead and put the 12-foot utility servitude on the south, on the west, excuse me, on the west. And so it's only in a building setback, not in a servitude.
Okay.
And they're gonna move those? They have intentions of moving?
No, we want to ask the Board of Adjustment condition upon us.
Yeah,
No.
and that doesn't fall under any kind of non-conforming or something, being that it's in a building setback?
It's not in the building setback now.
But it will
It
be.
is when you add a access servitude.
So that's the process, just get a variance from the variance board? Or
Right.
do we actually?
That or
give
move
the
it.
variance? Okay.
Open a public hearing. Is no comment, so I'll close the public hearing. Any further staff comment on this?
We recommend approval with all of the front setback issues being addressed either by removing the structures or variances granted. That, and he's fixed the turnaround. That was one of the comments I had on it before, so that's taken care of. So just with those front setback issues being resolved, we recommend approval.
So what would be the timeline for that? This would be contingent upon all that being done? Or,
Right.
so if they just decided not to move the buildings, what would happen?
Well, they have 6 months from the time y'all approve it to have it signed. So within 180 days, they'd
Yeah.
have to go to the Board of Adjustments and get the variances
The
or
next deadline's on
remove
November
everything.
18th, so we'll qualify for that next meeting.
So in 6 months, they would have to come back to let us know that they've done this? Or, I mean, how would we know that it's been done?
No. Well, I'll have to go check if
Okay.
they're removing them
Uh-huh.
or Lance will
Okay.
let me know
Lance is
that they
gonna
got the
give us
variances.
variance ID, which will then apply to the plat, stating
Okay.
that we received the variance before we get final signature from the chairman.
Okay.
Any further comment amongst the commission? In that case, do I have a motion?
Yeah, I'll make a motion that we approve it based on that, based on the variance being granted by the Board of Adjustments. Everything else is.
Do I have a second? Second. A motion and a second. All in favor?
Aye.
Those opposed? Thank you. The next hearing to approve or deny family partition is George Schneider property, McGlynn and Associates.
Here we go.
Ellen Jackson with McLean and Associates, representing Louis Schneider on this family partition, asking for your approval.
Is there any staff comment on this family partition?
Everybody's familiar with it already. The difference this time is that the lots have been increased roughly 1/10 of an acre, but everything else is the same. Who's receiving the lots, the access servitude, everything else is the same as it was the last 2 times. But the lots are bigger this time.
All right, in that case, I'd like to open a public hearing for comment on this family partition. Have you signed a card, sir? Can you do that? Identify yourself and make your comment.
Yeah, the cards. Oh, he's got one.
Okay, you already have one. All right, so you can go first. Please, everybody conform to the time limit, for the,
Again, this is the same variance as that was submitted 2 months ago and rejected.
Your name, please?
I'm sorry, my name is Leonard Gronowski. I'm a landowner in the immediate vicinity.
all right.
I have a home there and a family. But like I said, this is the same variance that was submitted about 2 months ago to y'all. It was rejected by all of you unanimously because it lacked merit. It's just, quite honestly, it's just an attempt to violate or bypass the ordinances that you already have established for I'll say subdivisions and trailer complexes or mobile home complexes. It's just an attempt to skirt all of those rules that are established already by using a variance. And I would like to see you reject it also on the same grounds as it was two months ago. Thank you for your time.
Thank you. Other public comment on this issue?
Larry Bates.
Evening, gentlemen. My name is Larry Bates. All my land borders on the west side of Mrs. Stafford's. Now, you heard us speak last time. We've been ongoing battle, as I would say. My request is that you do deny it. Reason why, I see deception. Of course, y'all are aware now of your major, I would say, your council meeting in which the loopholes have, hopefully, and I haven't read it, have been closed. And the situation has developed again is that now I'm getting trash dumped on my land, or let's say on the border of my land. Something I'm gonna have to further up on, with you guys later. But what I'm in question is that this keeps occurring. This is the second time this has approached you. I'm wondering how many more times this can be presented. The only thing's been changed, the land has been enlarged. Ricky had mentioned before, if it looks like a duck and it quacks like a duck, it's a duck. It's the same scenario. I'm just asking you, please deny it. We live there. We don't want a rural trailer park, and that's what's being developed. And I want to thank you for your time. Thank you.
Thank you, sir.
Dawn Gornowski.
Hi, my name's Dawn Gronowski, and I live on North Highway 936. And I agree with the previous speakers that you should have this denied because nothing has changed. It's still, he created his own hardship. And I'd like to know if if these gentlemen over here have found anything different that would enable it to pass, because as far as we know, we think it should be denied, just like it was previously. We don't see anything that has changed that would let it go past. So we would like to have it rejected again. So is there any reason why it would, that it could pass?
Ma'am, we're going to, conduct a meeting so that you address
Okay.
the council instead of
Is there any
staff.
reason why y'all would change
And-
and not deny it?
I don't want to be ugly, but we're not going to have a question and answer session.
Okay, I was just trying to get information, if there was any new information, because as far as we can tell, there's nothing that would change the situation, so we would like to see it rejected.
Thank
Thank
you,
you.
ma'am.
Lori Hoffman.
Hi, my name is Laurie Hoffman. I also live on Highway 936. Tonight, it's my understanding that the Planning Commission is here to enforce the regulations as defined in the Ascension Parish Unified Land Development Code. I'd like to read some excerpts from the code. Section 174026, Family Partition. Paragraph C. The chairman of the Planning Commission shall sign hardship family partition plats if the Planning Commission finds that a genuine hardship exists. In this case, I understand the proposed hardship is a lack of sufficient road frontage. Section 174093, variances. The granting of the variance shall be in harmony with the general purpose and intent of the regulations imposed by this ordinance. There must be a showing of unnecessary hardship. The hardship cannot be self-created. The last comment alone is more than sufficient legal ground for rejection, as the hardship was created by the owner when he subdivided this property in March of 2010. The facts are, the property, he originally has approximately 80 acres. In March, he divided a simple partition, dividing his land. 6 lots across the front of the property on 936, with being a little over ½ acre. Lot 1 is approximately 4 acres. Lot 5, which he's wanting to divide, 5A and 5B, and 5C, with leaving approximately about 70 acres left. And as we've said, he's only increased the size by a little bit. With the influx of people expected in this parish, it is more important than ever to ensure people are not trying to find ways to circumvent requirements such as those for subdivisions, trailer parks, etc. The Parish Planning Commission must be more diligent than ever in reviewing and approving these requests. Thank you.
Thank you very much. No more comment? Do we have discussion here on the council?
I'd like to address this briefly. A very similar proposal came to us a few months ago, and we rejected it. One of the questions being whether or not the family partition was subject to the variance requirements set forth in 1740-93, specifically whether or not the hardship can be self-created. Following that meeting, we were provided with a letter and some research done by the Commission's attorney in 2002, and there's quite a thorough analysis of it, concluding logically the standards imposed for granting any other variance would apply to the granting of a family partition. So at the time, we thought that it should apply. We didn't have any legal opinion on that. I think I'd asked staff about that. We do have a legal opinion by the parish that's 14 years old now that says, basically, the hardship can't be created by the landowner to rely on the family partition. I don't see anything here that's changed to that, and I think we're more grounded with that backup that the standards of variances apply to the family partition, which in itself is a variance of the otherwise regular subdivision rules. So I don't see anything different as to why we would now change our vote on that.
Well said.
Any other comment on the commission?
Yes.
Yes, sir.
To piggyback on what he just said, I guess my concern is, it says staff recommendation. Now, that being said, in reviewing this, and I recall the instance of the similarity, what has changed to say that recommend approval? Did not the variance, the problem be created by the owner? That being said, as he just read, he created the hardship. What is different now?
What's different is a tenth of an acre. As far as the hardship being self-created, that isn't something that's under the family partition regulations. Currently, it will be for next month. But right now, it's not. And this meets all the same requirements that every other family partition meets. The lots are the right size, they got the right size access servitude, providing utility servitude, everything else.
Specifically, before this item was rejected last month or the month before, whenever it was, I believe I was trying to make the statement that before this family partition, we had never gone and looked historically at every other family partition to see if their hardship was self-created. And so at that point, we didn't think it was fair as the staff to apply a standard that had never been applied before, ever. And so with the revisions to the ordinance that we've made, starting January 1, we will be looking at that. But for this specific application, it was considered an existing non-conforming application as far as we were concerned, and the onus of proving or approving the hardship is on the commission, not on the staff, because as far as we're concerned, the requirements in the family partition ordinance that we always have looked at historically have been met.
So what you're saying is from the standard of a hardship that's established being lack of sufficient frontage, lot size, those technical requirements, it meets those standards, but it's up to us to determine whether or not the hardship is a legitimate or legal hardship.
Yes, sir.
Okay.
Staff, how many times can this keep coming back to us that, they can make small changes like this? And, I mean, we had this 2 months ago, and we actually moved for denial. They're giving it back to us with minute changes. I mean, is there a limit to how many times they can take a stab at this?
The answer today is no. They
Okay.
could submit it every month. But I'll tell you, during the staff report section, we're going to present to you a revision to the code that addresses that very situation. I believe in my heart of hearts that what happened is this applicant missed the deadline to appeal their denial. And because we don't have something in place that prevents them from reapplying, they reapplied not knowing what the answer was going to be, but if it's denied, they're going to appeal that decision. That appeal will come back to you next month. If you deny them again, they're going to go to the appeals board and try their hand with another board to see if they can get it approved. We're also going to be looking at amending the appeal process because in our minds, it doesn't make sense for them to take their denial back to the exact same board with no new information. It's just a waste of our time. You're not going to be presented with anything new. So we're going to recommend amending the code to address that. We'll talk about that in the staff report section as well.
Is there any further discussion on this commission? Do I have a motion?
Motion to deny.
Do I have a second?
Second.
I have a motion and a second. All in favor?
Aye.
Those opposed? All right. Item 10A, Parker Place Estates. Public hearing to approve or deny the following preliminary plats. Parker Place Estates.
That's Mickey. Yeah.
Good evening. Mickey Robertson, MR Engineering and Surveying, 9131 Interline Avenue, Suite 3A, Baton Rouge, Louisiana. I'm here tonight to present the preliminary plat for a second phase of Parker Place Estates. During the construction process, a tract of land just to the west of the subdivision became available. It's approximately 11.7 acres, which by current zoning would allow roughly 36 lots. The plan you have before you tonight is only for 27 lots. We have addressed all of the drainage and traffic comments by the staff, and I'll be happy to answer any questions, but we're here tonight to ask for your approval. Thank you.
Thank you. Staff comment on this item?
All traffic concerns have not been addressed yet. He's now agreed to do what we have requested he do, but it hasn't been done yet. I wasn't there.
Sorry.
And that being said,
Okay.
He showed me the ASTRO guidelines and traffic counts for what he's done, and it looks as if when he submits it formally, it will be just fine. Everything will be fine. No left turn will be needed. No right turn will be needed. So he's taken care of everything he needed to do, as far as I'm concerned, as far as traffic is concerned.
All right. Is there any further staff comment? In that case, do we have? I'd like to open a public hearing for the discussion. I'm sorry, I didn't.
Just that contingent upon approval, he'll need to revise the lots 72, 73, and 74 of the existing Parker Place subdivision to remove lot 73 and put the road right-of-way and utility servitude and everything needed there and fix building line setbacks on lot 72 and 74. But
How many contingencies are we looking at? Are we looking at a contingency for the traffic impact study and the lot 73
the
right-of-way
traffic impact
situation?
study contingency was settled in the hallway.
So y'all finished that. So we're only looking at one contingency for
lots 72, 73, and 74.
Okay, just that one.
Okay. I'd like to open a public hearing for the discussion of this item. Has anyone signed up for discussion of this item?
Annette Martin.
Good afternoon. My name is Annette Martin. My husband and I have been residents of the adjacent property next to the proposed Parker Place estates for over the past 40 years. My biggest concern is the drainage of the land to our property. Our neighbors and I have seen more water standing after 2.5 inches of rain than we have after a hurricane. It took days for this water to exit the property. The first filing of Parker Place caused this. They are trying to drain 40 acres of my property into one storm drain, and it does not work. We are opposed to the new addition of Parker Place until the drainage problem is rectified. Our neighbors have experienced water 1 inch from entering their home since Parker Place has been under construction. We can provide pictures to show this, which you'll see next, showing something must be done now before the project can continue. In addition to the drainage, I would like to know the plans for the fencing between our property and the proposed Parker Place extension. We have cattle on our land and must have a secure fence at all times. We understand progress, but to go about it without consideration for residents that have been there for years is not acceptable. Putting water on the back of our property and devaluing our property is not the way to do business. No one can ever build on the back of our property now because of the restriction of the water that Parker Place has created. This must be addressed and rectified before anything moves forward. It is a health concerns. It's devaluing our property. It is not legal. If this was your property, you would feel the same way. Please do the right thing. Thank you.
Thank you. Next public comment.
Dawn Alamo.
Good afternoon. My name is Dawn Mayor Alamo. I don't have a speech like she does, but I do have pictures. I have lived on my property now for about 12, going on 13 years, and this year we had water up to the first brick of our house. Ascension shadows neighbors my property line. We went through all these meetings, went through they had, the Civic Center. A lot of us attended. They promised me the state-of-the-art drainage system, which basically was summed up with a day and a half of water sitting in my house like a little island, and they use an excavator to dig trenches through their nicely groomed 6 or 7 foot higher built-up land than mine now. And they came back about a month later, closed in that drainage that they dug with excavators, and now there are houses being framed and built on that drainage system. So I'm not saying that the subdivision is a bad idea. I'd never want to put anybody out of their home, but I do feel certain that I'm pretty much going to be out of mine in the near future because we haven't hit any hurricanes since this has happened. And they really just broke ground in January where I was. So that's pretty much all I have to say, but you could definitely see it for yourself in the pictures because it's a sight. So I have them for anybody to look at.
You put them on?
I don't know if it'll show on there, but this is just basically my front door. That water was touching the foundation of my house. My walkway was under, my driveway was under.
And when did this take place?
This was just that last big rainstorm we had in about 2.5 hours. The water came up that quick. There's a limestone driveway that's normally right there. There's grass, trees. This would be my driveway, which is the next one, looking from where my house is up to Abby James. And we couldn't even take our vehicles down it for the fear of our cars would have flooded. So a truck could get back there, but because the water was so close to my foundation, I wouldn't allow any traffic because I was afraid the ripples would push it up to the bricks and then it would soak in. But I have, this would be, and my shop did get water. I had about 8 inches in I have a 40 by 60 shop next door, and I mean, to the back of the house, and that actually did have water. I have some pictures, but this last picture is the drainage, because I know I'm running out of time. But this is their trench, and this property is ours back here that it leads to in the back. But they dug that trench, and that was it draining on the road of their subdivision.
So you're saying you've been here for 12 years, that you've never seen this kind of flooding in 12 years
Never.
on your property at all?
We had water come up in the, like where their, so to say, ditch is. where my driveway is. It would come up over the rocks, still far enough away from my home. My shop never got water in it. I literally, the rain started that day. I was driving home from work. My daughter was inside the house doing her homework. She had no idea what had happened around her. And when I went to drive down my driveway, I called her and I said, baby, you don't even realize you're about to flood. She walked out the front door. She was like, oh my gosh, this was not here just an hour and a half, 2 hours ago when I walked the dog. And all of a sudden we were surrounded by water. So needless to say, I did panic, yeah. I did, however, consult my insurance company, and I am not in a flood zone. His best advice was for me to take out a flood insurance policy, so for $400 a year, I'm insured. So my belongings are covered, but I can tell you my mentality and my mental stability, when it comes to this, no insurance can replace that. And I don't know, I just would like to be more involved in knowing how this gets passed, because I, for the life of me, can't imagine Ascension Shadows was okayed for them to go that high of an elevation if they did everything they were supposed to do by the book. Now I didn't even know this other subdivision was in place, so.
Thank you, ma'am.
Till yesterday.
Thank you. Is there any further comment? Is there another person? Any further staff comment on? Yeah, I'd like to close the public hearing now also, but any further staff comment on this? Okay, and any other comment?
Probably the biggest comment that we heard was certainly in regards to drainage. And I think we're all aware of the storm event that occurred several months back was somewhere in the neighborhood of a 200 to a 500-year event. You know, we've met with the parish president, we've talked with DPW, so we understand that that was a major event, something that we have never seen, certainly not in the last 12 years. The good news is there was no water in our house, so and we did send the contractor out there to dig that temporary ditch to provide some relief because we were during the middle of construction. We didn't have all of our drainage in place yet. We're still had the temporary situation. But I don't think, we certainly haven't had a rain event like that since then, but we also now have the permanent drainage in place, and everything seems to be operating properly. So I don't, that was a temporary situation. In terms of the fence, with the cows that we heard from one lady, I do believe she has a fence along that entire property line, so we're not going to be taking down anybody else's fence. That's really not an issue. On that southern property line between Miss Martin's property and ours, that's where our retention pond is going, so we're actually going to be stopping some of the water that's going across our property into hers, and we're going to be, bringing it into our detention pond and taking it and routing it out. With that being said, we met all the requirements of the drainage study, and we just ask for your approval. Thank you.
Okay. Any comment further?
A question of staff. I just want to get a clarification about just the whole process with Parker Place, Phase 1, Phase 2. Now, Phase 1 was, how many lots? It was
88.
88. And it was like approved and developed as a separate subdivision from this other one. The other one, you just found some more land adjacent. So, I mean, it was done, I guess, as two separate subdivisions, but in reality, it is one contiguous subdivision. And of course, you have drainage studies that was done on both of them. You have traffic impact studies that were done on both of them. Would it have made a difference if it had been one subdivision as opposed to two separate? I'm thinking in terms of drainage, the fact that one was done and then the drainage impact was just on the last, 20 lots, 30 lots? Would that make a difference in how this was all done? I'm just
On the traffic study, we actually considered all 115 lots on the new traffic study that we did.
Okay.
As to whether or not a turn lane would be required.
Yeah.
On the drainage study for the initial 88 lots, we accounted for 60 acres coming from this side of the property, of which this is a portion of it. And we, put a detention pond on this property that maintained the flow to those conditions that were met in the original drainage study. So you had a certain amount of flow coming that way. We detained it and kept it to that, actually a little bit less than that, those numbers. So it was kind of all considered as one when we submitted this.
So Ms. Martin's existing 40-acre watershed, that's all coming to you through a catch basin, through something that's going to be taken into your system?
Back there, right.
Okay. And then what Ms. Alamo's having problems with on hers, and I don't mean to put you on the spot, Mickey, but I mean, this is something that backs up to the original 88 lots, correct?
That's correct, right? Mr. Alamo's down in the southwest corner.
I mean, I've seen projects before to where when you're in the middle of construction, sometimes your drainage isn't complete. I mean, I'm hoping that this is
It
one of
is.
those
And a
situations,
lot of
but,
it,
you know,
believe it or not, it's a catch-22. A lot of it had to do with the erosion control that was stopping the water, you know, because that's what it's there for, is to slow down the water so that the silt settles out. We went out there and we had to remove some of the erosion control to let some of the drainage out.
Yeah.
And, that happens during the middle of construction, but to our contractor's credit, he was on the spot. He did go out there and take care of, what needed to happen during that time.
I mean, as far as the preliminary plat, approval process goes, I mean, we have to trust the process that's in place with approving a drainage impact study and such. I mean, it's just something that we have to trust. I mean, if there's water that you're putting on someone else's property, you're opening yourself up to someone filing suit against you. I mean, there's, state laws that protect that, but, I don't know, are we
I'm
closed
glad,
on-
I'm glad that you use that term trust. It's my understanding that there was an inadvertent mistake addition to the plat that was presented where there was an addition. An asterisk.
Oh, yeah.
I can speak to that.
Now, let me speak. As a former chair of this commission, we depend on the trust of the people we deal with. And it may have been inadvertent, but it was a significant inadvertent addition. And I would tell you that it would not be wise to have any more inadvertent additions to plats, regardless of who you say you talked to or didn't talk to. That's just not the way we do stuff. So that's my advice.
Whether you let me or not, I'm going to speak to that because that's a little offensive because and so everyone's clear, there's lot 72, 73, and 74 in Parker Place. Lot 73 was, when it was submitted originally, it was not shown as a future right-of-way. During that time frame, between the time we submitted it and the time it got approved, this property became available. So we said, well, let's reserve lot 73 for a right-of-way. We had a meeting with staff, and we were directed by staff to add an asterisk to the plat and say that this is designated for a future right-of-way. And that is what we did. So I want to be very, very clear about that.
Staff?
I will speak to the fact that I have no recollection of the conversation. I'm not saying it didn't happen. We meet with a lot of people. But when Ben and I searched for a paper trail of said conversation, we couldn't find it. So that's when we put our recommendation together, was simply stating, hey, look, we don't know where the asterisk came from. Let's go ahead and address this. When we met with Mickey last week, we came to the resolution of doing the re-subdivision of those lots to address the issue. And I don't disagree with you, Mr. Burgess. We need to ensure that no inadvertent asterisks occur. And I would just advise Mickey that in the future, let's go ahead and send an email to say, hey, I'm confirming that you told me to do this, because once again, I have no recollection, Ben has no recollection, and I'm not saying it didn't happen. I just do not recall it.
Fair enough.
Yeah.
I'll agree to disagree, but I stand by my comments.
Okay. So
All
he
right.
said, she said.
Do we have further comment? Do I have a motion in that case?
I'm gonna make a motion to approve the preliminary plat with the contingencies of, what are the contingencies that we have? The, lot 73, provide the adequate right-of-way and, utility setbacks on it. The one contingency, right? Yes.
I'll second that motion.
I have a motion and a second. All in favor?
Aye.
Aye.
Those opposed?
Opposed.
Oppose.
So the ayes have it. Thank you.
Thank you.
All right. Item 10B. Public hearing to approve or deny the following preliminary plat Legacy Oaks.
Good evening. My name is Derek Murphy with Quality Engineering and Surveying, representing Legacy Oaks LLC tonight. This piece of property was before you a while back as a PUD. As you can see, it is now not a PUD, but a traditional type subdivision with 127 lots, which meets the recommended or the required density. We have submitted a revised drainage study to meet this actual plan. It has been approved. We have, talking to staff, they have allowed us to use the original traffic study because the traffic study was based on 155 lots, which did not require any improvements. We're now to 127 lots. So we have approval on the traffic study. During the last round of approvals going through, we had several comments from adjacent property owners who were concerned about the drainage and traffic, as you can aware of. And so we do have those approvals in place right now. We do meet the code, and we are within lesser density than what we originally had. This meets the zoning as it applies today. We have, as you see in the staff recommendations, they have recommended approval. We do have one variance or waiver, if you will, on a 900-foot block length for 60-foot lots. The reason of the replacement of the crosswalk is because we felt that that was the best place, us and staff, because lots 28 through 46 were going to be facing West Main Street, and that was just a natural break to where it would be a crosswalk where the lots actually faced a different way. We're asking tonight for your approval, and look forward to answering any questions y'all might have.
Thank you. Staff comment?
He was so thorough. The traffic study's been approved, their drainage impact study's been approved, and the plat meets everything it needs to meet as far as subdivision regulations, minus that block length that he was talking about. That is between, on Legacy Lake Drive, between lots 85 and 101. That was, it's roughly 1,200 feet, if I remember correctly, and the maximum block length is 900 feet. So they're a little over, but we are okay with them getting a variance on that, because when you get to lot 27, he said 28, but this says 27, lots 27 to 46, those houses will all be facing out to West Main. So you don't get the front of house for 2,000 feet straight.
In the previous hearing, when there was some discussion about the sewer system that they would be sharing with the school next door, could you address the sewer system? Yes, sir.
As shown on the preliminary plat, we have a sanitary sewer treatment plant adjacent to the school site, but we are completely separate. We are not tying into the school site at this time. So we're asking for our own plant with our own discharge, just like its own sewer system. So we'll not be tying into the school.
Thank you. At this time, I'd like to open a public hearing on this subject.
Ronald Daigle.
So all these lots face out to West Street.
My name is Ronald Daigle. I live directly across from this proposed project. The landowners and I on Cornerview Road have quarter-acre lots or larger. Along with my neighbors and we oppose this project change. I have lived here all my life and plan to live here the rest of my life, along with the rest of my neighbors. We are not concerned with the property value as we are trying to maintain our current quality of life. We think this type of change will definitely change our quality of life because of the increased population. So please, no townhouses, regular homes with good lots. This is the second appearance of this group for a higher population density for this parcel. So we ask you to please deny it.
Thank you.
Thank you.
Next speaker.
Stephen Abramson.
Good evening. Thank you for hearing my address. My name is Stephen Abramson, and I live at 39528 West New River Extension, directly across from the planned Legacy Oaks subdivision. My main concern is about the drainage impact on my property directly across New River, which is not in a flood zone. The culvert exiting Legacy Oaks on New River is aimed directly at my property. I understand that there is an external group of engineers, not the parish engineers, involved with the study and implementation of the drainage. I just want to put the Planning and Zoning Commission on notice about the drainage problems and our concern. Since this is a preliminary plot to be acted upon by you, my wife and I would like to be notified by you of any future changes that come before you so that we can attend the meeting and also have prior review of the changes. One thing I'd like to ask on this new plat, it's item number 8. I don't know if you have it. And it says, any new drainage ditch required by the subdivision of this property for the purpose of transporting runoff or sewage treatment plant effluent to an existing parish maintained ditch shall be constructed and maintained by the property owners. I don't know, I mean, are there any more drainage ditches planned? I don't know, and our concerns is about the drainage, and I appreciated looking into this, and also about if there is an external group of engineers other than the parish that are doing this, sewage and drainage development. Thank you so much for listening to me.
Thank you.
Thank you.
No other speaker? Would the staff, could you address Dr. Abramson's two concerns there about?
I'm gonna, I guess, defer to Representative from T. Baker Smith, who is the ERA consultant for this project, and he can discuss the review process of the drainage impact study and how it satisfied the parish code.
How's it going? My name's Kevin Byer with T. Baker Smith. We are doing the external engineering review on the drainage impact studies for these projects. As far as what the parish codes and ordinances state, this project has designed and detained water for the 10-year post-development flow to do everything the parish says as far as retaining it to the pre-existing 10-year storm event, and has, at this time, looks to have all the right checks in place to be approved, and so we recommended approval on the drainage side.
Thank you.
Kevin, can we speak, on part of this 48-inch existing outfall pipe that they have going underneath the road?
Oh.
As far as what the drainage is, and to address what Mr. Abramson was talking about, that pipe is their outfall and it's facing his house. They can't increase the volume of water that comes out of that pipe going through their subdivision, correct? I mean, whatever's coming off that property into that pipe now has to be matched after they're finished developing this property?
That's right. They're not dumping any more water off of the property than what it's already having coming off of it pre-existing today.
And that's part of what the drainage impact study.
That's right. So we go in and
ensures.
review that the pond is sized right to hold back with all the new developments, concrete houses.
Right.
That the additional runoff that's going to be there from a 10-year storm event will be held back to what the pre-existing, and then the pond will rise up.
Yeah.
Smaller outfall pipe going out, and nothing should change to the surrounding areas.
Just like to try to ensure people that, to try to walk with us on that vote of confidence that that's going to.
It is considered the zero impact rule of not dumping off more than what you're designing for.
Is there further comment on the commission here?
I don't feel like everything's been met.
I have a question. Would you consider this project, will it change the character of the immediate environment? And that could be staff or anyone. This project, will it change the character?
I mean,
Of
we're
that
going to
environment.
speak at a 30,000-foot level. Any project is going to change the character of any community where it's located because it's new. I think that the regulations that are in place with regards to drainage, quality engineering, it's their job to ensure that the quality of the drainage isn't going to get worse. I drove Main Street during the last big event. Water crosses Main Street in 5 locations. I mean, I'm not exaggerating. Water crosses Main Street. You can't expect this project to solve that problem, but this project can't make that problem worse.
Exactly.
Is the density or number of houses going to change the character of that community? Sure. But the parish council is the one who drew the zoning map. The parish council is the one who said 3 units an acre is the character of this community. And this applicant is providing a new development. It's not a PUD that meets the code, that meets the park requirements, that's going to do all that. The sewer questions is a great question. We thought all along they were tying into the school. Agreements couldn't be reached, so they're going to provide a new sewer plant. And as far as I know, that sewer plant will be one of the new plants that come into the parish's control, and we're going to have that sewer. That'll be a parish-controlled sewer plant. So as far as changing the character, yes, it's going to. But literally, a Dollar General built in Santa Mall changes the character of that community as well.
Well, my concern is, I guess the question would be, if you assess the environment right now, is it rural, urban? Before the project, would you consider rural or urban?
It's suburban.
Suburban. And the reason I asked that question, the third principle in zoning, preserve the rural character of the parish. And I guess my concern is this project in that area, I want an answer.
I think the zoning map does not preserve the rural character of this parish. So by virtue of that document alone, you have not adhered to that standard of the master plan. And so the zoning map dictates that you can get up to 3 units per acre, and the code provides them the tools, the developer, the mechanisms to get to that density. If we're going to start evaluating whether or not a subdivision is going to damage the rural character, you really need to start evaluating your zoning map to determine whether or not 60% of this parish should be zoned 3 units an acre, because that's the question.
Our next step would be to step back to 1 unit per acre like we have in rural.
Rural is 1 unit per
towards-
10 acres. Let's not kid ourselves. Rural
Wow.
is much, much less dense.
Wow.
This entire parish is suburban, because our lowest density is 1 unit per acre. That's not rural either.
No?
You've got to go to Donaldsonville to start finding rural, where you've got farmland and you've got giant tracts of land with one house on it where they've been farming sugarcane for decades. That's rural. We don't have rural on the east side.
You said it well. We would have to start the zoning map if you wanted to preserve the rural character. And right now it is. It's set for 3 units per acre. I mean, that's what we decided on in 1998-ish? When
Yes,
we
sir.
put the zoning in place.
And also, I think Ricky's saying you can't preserve what doesn't exist.
Can't preserve what doesn't exist. Right. That kind of zoning in this area.
Well, there is no rural, so you cannot preserve it on the east side of the parish.
As defined by our zoning map.
As defined by what the definition of rural is, because there's no place with 1 house per 10 acres. Anyway, I don't think I ever closed the public hearing, so I'd like to close the public hearing and ask if there's any more discussion on the commission about this item.
No.
In that case, I'd like to call for a motion on this item.
I move to accept.
I have a motion. Do I have a second?
I'll second that.
So I have a motion and a second. All in favor?
Aye.
Aye.
Those opposed? Carries. Thank you. The next item is 11, public hearing to approve or deny the following overlay zone site plan review. A, pre-development meeting for revised historical overlay site plan for Homa's House Plantation and Gardens.
Mr. Chairman and members of the commission, my name is Kevin Kelly. I'm here to answer any questions, I suppose, about this revisement of our historic overlay site.
It's a great package you guys put together.
Thank you.
It's a really nice package.
For the benefit of those that don't have the package in front of them, could you give us a kind of a summary description of what you're trying to do?
I guess the primary change is the already approved Steamboat Museum, which was going to be on the Batcher side of the river, is now going to be on the land side of the levee. And if you've been to Homer's house, it will be, there's a circular park area, and it will be between the circular park area and the parking lot. So it will have frontage on the main parking lot, and it will have a separate entrance at that site. We were never able to get a permit to build the Steamboat Museum on the river. The Corps of Engineers and the navigational engineers decided that the river was too dangerous in this area, and that at times when the river was very high, a ship could hit it if it had broken loose. Say a barge broke loose, it could have hit it and endangered the lives of people who were in the museum. So they wouldn't allow that. So we've gotten the approvals from all the different organizations required to build it on the land. We will still have the bridge crossing over River Road. On the top of the levee, it will basically be an interpretive area, a concreted area that goes for about roughly 800 feet, where there will be benches, lighting, exhibits on the levee where you'll be able to look into the river or look at the river and see the activities of ships going by and the other navigational things that are in that area. So this is the approval to do that. It's also to add a service area to the pavilion ballroom, which was established in 2004 or 5, I believe. So this is adding on about a 20-foot by 40-foot area to it, which is primarily storage area. It's to build a small warehouse for receiving that will receive all items for the plantation, including the Steamboat Museum, and that's what's called the storage area. And there's 2 pigeon airs that are being built near River Road, which will allow storage of water. Our water gets disconnected frequently. And about 2 years ago, when the symphony was playing for Christmas, we didn't have water for about 4 hours. And I hate to say it, but even though we have 30-something toilets, they were all filled, and it was quite embarrassing. So we're now putting storage tanks in where we'll be able to have about 4,000 gallons of water to allow toilets to flush if the water gets discontinued. We have a lot of entertainment events and weddings and things like that, and it's just personally embarrassing when you can't use it. Let's see, what else is there? Those are the primary things being built now, and it proposed, because the Steamboat Museum is going where it is, it forced us to move where the proposed hotel was. I'm not ready to build a hotel, and any of the hotel or conservatory buildings would have to come back for a permit at a later date when we're ready to do those. So those really aren't proposed to go right now, but they probably will in several years.
Thank you. Yes, sir.
You've been in communication with your adjacent landowners throughout this process, I assume, and is there any concerns on their part? Have you? I mean, who are they, and have you been in contact with them?
There's a cement plant that's to our upriver side, and it's a concrete silo industrial facility, and no, we haven't. To our lower riverside is also an industrial site. It's called, is an inspection services, and no, we haven't. Not for the movement of the building there, but they were previously aware when we had the Steamboat Museum designated to go on the other side of the Batcher. Moving on this side of the Batcher, I don't think makes any difference in any way that would affect them.
But
no,
they didn't. They never expressed any concerns.
No, there've never been any concern to us.
Out of
Either way, they're both good neighbors.
Out of curiosity, after all of this is built, how will the steamboats that are visiting you, where will they dock? Will they dock at the interpretive center, or do you have a special place?
No, because the interpretive center really is on the top of the levee now, and totally in our parking lot. There is the Batcher landing is there. It's natural the way steamboats have docked there for 203 years now. It's just where they put their gangplank down on the Batcher. When the river gets very high, many times they can't dock there, so they'll go other sites. But nothing will be changed there. They would not allow us to build a physical docking facility there. I wish they would. We'd love to have the steamboats dock and stay there for a couple of days at a time, but it's not allowed.
Okay, is there any staff comment?
Sure. So we've met with Mr. Kelly on several occasions, and I too appreciate the quality of the package that was presented to us, because when we first started talking, it was, hey, we need to move the Steamboat Museum. And as the conversation evolved, it got to, oh, and we want to do this, and we want to do this, and we want to do this. I said, well, let's build a package. Let's have something we can present to the commission that says, here's in total what we want to do today. And, you know, if you scroll through the package, there's a couple of pages that talk about, here's what we're going to do in the future. We're going to come back to you when we're ready to do those. But what we wanted to do is put it in the package to say, commission, please be aware, we're not done at the Homeless House. This project is going to continue to evolve. These buildings may continue to shift and change and whatnot. But I think what Mr. Kelly and Mr. Blanchard have done is present to you guys a complete package for 3 years, 4 years, for what they're going to be doing in the immediate future, and then a 10-year plan for what the plans are for the future. And we have no objection to what they're doing, because we think that this is one of the jewels of the parish, and it needs to continue to do what it does and attract visitors and just be a great place to visit.
Attracts visitors with money.
So Ricky, what exactly are we approving or denying here? We're approving a plan, or are we approving to physically
Okay, so
lift the
this
overlay?
package is a revision to a package that was approved 3 years ago, 4 years ago, 4 years ago, whatever it was. So this package will be the package in our file. The next time he submits a plan for a building permit, we will look at that plan and say, okay, that's building 4 on the proposed buildings that was approved. We look at it, we review it, we look at all the things we look at, and we say, you meet it. If he presents a building to us or a revision that's not part of this, we'll tell Mr. Kelly, you've got to come back to the commission to have that approved. But what you're approving today basically is all of the buildings and all the elevations and all the stuff on all of those proposed buildings on that page.
Oh, okay. We're approving those 4 buildings for right now. I mean, there's water storage towers and cottages. I mean,
Number 6 is a reception center. It was
Oh, it
previously
does look
approved, but we've added details that talk about, you know, what all's going to happen there, what's it going to look like. That was already approved, but we didn't have the details in the earlier package, so now we're getting details. When he submits a new revision in 4 years, it'll look like this, but it'll have a bunch more pages. As here's now, these buildings are now existing. Here's our new proposed buildings. Here's what they're going to look like.
now, the reason that this has to come to the commission is because it's in the historic overlay
Yes, sir.
zone. I mean, anyone else does anything with their property.
Correct.
We
Well,
don't
he
have
is
to see it.
zoned, and this has been one of those things. He is zoned conservation. Well, conservation is 1 unit per acre residential. But because he's a historic site, he has the star on the zoning map, and that says, look at the historic site overlay. Here's what you're allowed to do within that property, regardless of the zoning.
The overlay lies on top of
Correct.
the,
It supersedes what's allowed with the zoning.
okay. So that's why we see it, and that's what we're here to approve, whether or not we agree with what he wants to do within that overlay.
Correct.
Okay.
All right. So at this time, I'd like to open a public hearing for the discussion of this project. So is there has anyone signed to make a comment? In that case, I'll close the public hearing for this project and ask the commission if they'd like to make any other further comments. In that case, do we have a motion?
I move to accept.
Do I have a second? I think I have a motion and a second here.
Either way you want to do it.
Okay.
Mr. Chairman.
All right. All those in favor?
Aye.
Those opposed? Thank you. All right. Item 12, ordinances, public hearing to recommend approval or denial of the parish council amendments to the Ascension Parish Unified Land Development Code. A, ordinance SR 14-11, revisions to the subdivision regulations in the Unified Land Development Code pertaining to townhouse subdivisions. Staff?
So last month in the staff report, we talked about our revisions to the regulations on townhouse subdivisions. So this month is public hearing. What you have in your package is basically what the code says now, and then what we're proposing. If you go to the last 2 pages, is a simpler outline of what is existing, and that's what's in red, and what we're proposing, all the new stuff and things that we've revised to be more specific and what we will not allow. We've added a minimum living area of 750 square feet. The setbacks, we've revised the way that they were written. They were in there before, but it was kind of worded funny. Recreation area, we've defined how big that needs to be, what does and does not count towards that area, and how it needs to be located within the development. Parking requirements, we've added stuff in there about guest parking being parallel and the size of the parallel parking space needs to be. Access drives, we've added that they need to meet the parish's standards for streets now. We've added in there placement and screening of utilities. Some stuff about the facades of the buildings, what they can, can't do, fence requirements, heights, materials, and we've decreased the density that we'll allow within townhouse subdivisions by up in the 5,000 square feet per dwelling unit as opposed to 3,800, what we had before.
Thank you. I'd like to open a public comment period for hearing for the discussion of this ordinance. Has anyone come forward? So in that case, I'm closing the public hearing. Any discussion here among the commission? So do I have a...
Move for approval.
Second.
I have a motion and a second. All in favor?
Aye.
Those opposed? Thank you. Staff report?
Okay, so as I spoke about before, I have 3 items that I'm going to request a public hearing for next month. And so I'm going to have someone come hand these out to you. Someone. So, item number 1, we're calling SR 14-12, revisions to the subdivision regulations in the Unified Land Development Code pertaining to appeal procedure.
Thank you so much.
So currently, the regulations state that if an item is denied, and it actually doesn't say if an item, it says if a preliminary or final approval to a major or minor subdivision. So really, it doesn't address family partitions, it doesn't address any of the other actions you would have taken tonight, other than major or minor subdivisions, that they have to come back to you for an appeal. They present the case again, and then assuming you deny it again, then it goes before the appeals board. So what we're doing is we're amending the code to simply state, if it's denied here, they submit an application to the secretary within, I believe it's 30 days of that written decision. So next month, you guys will put out minutes for this meeting. They have 30 days from that date that those minutes are approved to appeal the decision. Then it'll go straight to the Planning Commission Appeals Board, and their decision is final. It just saves time. It doesn't make a whole lot of sense to come back to the board that originally denied you with no new information for an appeal. That's it.
So I think we need a motion to place these on the agenda for next meeting.
For a public hearing.
For a public hearing.
If you guys agree, or if you don't, we don't have to do it. I don't know.
3 members of the planning commission appointed by the parent?
No, there's a separate board called the
Okay.
Planning Commission Appeals Board.
And that currently exists?
Yes, sir.
Okay, that was my question, if we would have to go back at it.
Who's on it?
Anyone yet?
I don't know. There are 3 members.
Oh, okay.
We haven't used them since I've been here.
Okay.
I mean,
So there have been no appeals?
no, sir.
Okay.
Would they be present for the public hearing?
Wait,
be nice.
say that again.
Would they be present? You're requesting to have this placed on next month's agenda. And we're talking about a public hearing, is that correct?
Yes, sir.
That being said, would they be available? Like to understand what their job is.
Well, their job is essentially still the same. We're just taking away a 30-day period that the applicant would have to wait for their job to actually become engaged. I mean, literally, this board has been together now 3 years. You've had how many appeals come to you?
I don't think any.
None.
We know
I think we've done one since I've been here, and it got overturned at the commission because the commission realized they had done something they shouldn't have done. And so the appeals board, at this point in time, is a formality. However, with this application that we've seen now for a couple of times with the repeat denials, I know it's going to become something for that case. They're going to come back to you. I just like to have this in place for the next one because it just doesn't seem to make sense. We tried to change this with the previous commission, and I'm going to be honest with you, the revision that they wanted to do was crazy, and so I dumped it. I said, we're not doing that. This version just makes a lot more sense.
So all I'm asking for here is a
I
motion.
move to put it as a public hearing at our next meeting.
I'm sorry, Jackie, I didn't answer your question. I don't believe I would invite them because I'd still like to keep them out of the loop. To me, they need to be a non-biased. They will hear the case completely brand new when it goes to them. They will get the minutes from your meeting. We'll offer them recordings of if there's 1,000 public speakers so they have an understanding of what's going on. But no, I think I'd like to keep them out of the loop because their job is still essentially the same.
I guess my concern would be is, I would think they would have the right to reject the appeal without going through anything. Is that correct? If it doesn't meet some standard, why go through the process?
I think that the standard that we're saying that this item in particular
Yes.
is a judgment call. You know, they would argue that we believe we do have a hardship. And you guys have stated you don't. They want to go to a new board that says, do you guys think we have a hardship? And it gives them 3 more heads to basically try to convince. That's essentially what it is.
That's fair.
Which it already exists now.
Yes, sir.
So we're not changing it, we're just shortening the gap to get there.
Yes,
if
sir.
they so choose.
Yes, sir.
Well, since it's never been used and we don't know who they are, it might be good if we ask the parish president or whoever the appointing authority is to give some thought to who should be on that board.
The board exists. We had somebody who either died or stepped off the committee since I've been here, and I know that some person has been put in that spot. Who the other 2 names are, I just don't know them off the top of my head because, once again, we've never used them. They exist.
I'd like to make a motion just to put this as a public hearing for our next meeting.
I'll second.
I'll have those names for y'all at the next meeting.
It is a legitimate concern, and suppose there's a conflict of interest for someone's on the board. Will we know this?
They would just have to recuse themselves if they had a conflict.
And the parish president, I guess, would have to appoint a
But
4th
certainly,
person.
And we
A
don't have any
transparent
control over
process would make certain that we would understand it.
That's a good point.
They fall under the same code of ethics that you do. They're appointed officials just like you are. So if there's a conflict, they're required to disclose that.
Okay.
And recuse themselves, if that's a possibility. It would be recusal or step off the board.
And this is just for a public hearing to discuss it anyway. So I
put it
think
on
I
the
have a
agenda.
motion in
For
a
the public
second.
hearing, yes.
So, I know I have a motion. Okay, I have a motion in a second. All in favor?
Aye.
Those opposed?
Yeah, and then
All right.
2 more.
Okay, the issue isn't,
All
for me,
right.
wasn't the public hearing.
What's the valid concern about the,
Yeah.
comes down to
know who
just
they
2
are.
people, you can't have a vote of 2.
One yea, one nay. Yeah.
Thank you.
Thank you again.
What if somebody had to
Okay.
recuse themselves?
Okay, so the next
Mr.
item
Compton?
that I'd like to talk about is item SR 14-13, and that's pertaining to the resubmittal of items. So when we were asked whether or not a particular item could come back to the commission, the code is silent. It doesn't speak to what it takes to resubmit an item back to the commission. So what I'd like to do is I'd like to add a section to the code that's called resubmittal procedure, and it reads like this. If the Planning Commission denies an application, the applicant has the option of appealing the decision as defined in Section 17-4092 or resubmitting the application if the following conditions have been met. 1, at least 12 months have passed since the original hearing date, or 2, changes have been made to the original application that address the concerns stated in the commission's decision to deny the application. If you haven't met one of those two options, you cannot resubmit.
Under this, Ricky, who would decide whether or not the changes address the commission's denial?
I'm assuming staff would. I mean, as a body, when you deny an application, you have to give a reason. And if your reason is, we don't believe, I mean, we were throwing around examples, what kind of decisions would it be? Well, they provided a 30-foot servitude, and you guys said, no, the code says a 40-foot servitude. They didn't want to do it. You guys deny them, and they come back to us. If it comes back with a 30-foot servitude, we're going to say, you haven't met the condition. If it's a T turnaround or an L turnaround or some other thing, you've got to satisfy the requirement for why you were denied. If it's so gray, then we probably put it to you guys and say, Commission, we're looking for some help. Do you guys believe they satisfied? And we put it on the agenda as a resubmittal and let you guys decide if it's that gray. Black and white's easy for us.
And well, the 12 months is black and white.
Yeah.
I mean, there's no discretion in that. But this is just for a public hearing?
We would like to request a public hearing next month.
I move for a public hearing
I
on
have a
this.
motion. Do I have a second?
Second?
I have a motion and a second. All in favor?
Aye.
Yay.
Approved.
So my wonderful staff has informed me that the names are online. Fritz Anglad, Sam Spelagine, and Brian Aguilar are the members of the Planning Commission Appeals Board.
Fritz Unglot Jr. or Senior, does it say?
Yes.
Did you see that?
It's in the family.
All right.
Isn't that the developer who's here?
All right, so the third item is one that came to our attention today, and it was of such immediate concern. I drafted this up today so that we could present it tonight and have a public hearing next month. The purpose of the proposed revision is to revise Appendix 12 of the Unified Land Development Code to address covering the costs associated with needed signage when a new private street is created. So we approve a family partition on Ricky Compton Lane, and I come to the parish and I get an address on Ricky Compton Lane, and today the burden of the cost of that sign is on the parish. The parish pays for that new street sign, the pole, and the hardware. I want to create a fee structure that allows us to charge the applicant when they need a new street sign for the actual cost of that sign. So $100, I rounded up $15 because there is a cost associated with a crew going out and installing that sign. And I added some language that if the fees for the signs, the brackets, or the pole go up, we can go up with the fees not to exceed 10% of actual cost. So what I'd love to do is have a public hearing on this in December so we can get it passed in January. It is of urgent need because our legal counsel has stated that we cannot use public dollars to spend money on private property. We can't buy these private signs, but if we can collect a fee, then we've satisfied that need, and it's primarily for 911. We, as the parish, we're the addressing system for 911, and when those signs go up, that's so 911 services can find these newly created properties.
I move for a public hearing on this.
Yeah, I'll second
I have a
that.
motion and a second. All in favor?
Aye.
Those opposed? None. So be it. All right. Engineering staff report.
We have nothing for this meeting.
Okay, motion to adjourn.
Second.
Second.
All those opposed?
Yeah, right.
We are adjourned.